Slam dunk, are you ready to meet me? I'm lit and I'm riding the fast lane. Don't let me down, I'm on fire. Does anyone else feel like a liar? It's all in your head and right. You just never use it.
Thank you. Good afternoon, Honorable Justices. My name is Drayden Lee. My co-counsel, Ms. Dowling, and I are representing the plaintiff, Mr. Stark, in the present matter. Today, I will be speaking about the requisite standard of care for medical negligence in Canada, as correctly applied to this case. Ms. Dowling will then address the issue of causation and will conclude with a discussion of vicarious liability. I will defer to the facts as just stated. Since it is our contention that Dr. Lutzire was negligent in his care and treatment of Ms. Stark, let me begin by setting out the necessary components of negligence. A successful action in negligence requires 1, that the defendant owed a duty of care, 2, that the defendant's conduct breached the standard of care, and 3, that the defendant's breach caused damages in fact and in law. It is well established under the common law that a medical practitioner owes a duty of care to their patient. Therefore, I will focus my submissions on the requisite standard of care for medical negligence in Canada as applicable to this case. The test for standard of care in medical negligence is a test of reasonableness. As outlined in Critz and Sylvester, every medical practitioner must bring a reasonable degree of skill, knowledge, and care to the task at hand. A practitioner is required to exercise the same degree of care and skill as would a reasonably prudent practitioner of the same experience and standing. We would like to stress something about the standard of care. It is based on reasonableness. Our submission is that it is unreasonable for a prudent medical practitioner in Canada to blindly follow protocol and to cast aside other methods of treatment as propaganda when that protocol has proven ineffective. This is supported by both the expert testimony and prior Canadian jurisprudence. During their testimony, the experts, Drs. Strange, Titchener, and Moriarty, all agreed that the standard of care involved due diligence and an investigation of the literature Dr. Lutzire was provided with to make an educated decision regarding treatment. I refer the court to paragraph 38 of our factum. There you will note that when asked about the standard of care, Dr. Strange denied Dr. Lutzire's conduct was reasonable, prudent, and diligent. She specifically stated that the standard of care of a prudent physician would have been to review what I sent or conduct your own detailed investigation, then make a decision, an educated one, an evidence-based one. Dr. Titchener agreed with Dr. Strange that the standard of care involved conducting due diligence. Dr. Moriarty, who I would remind the court is the expert for the defendant, took time to review the literature that Dr. Strange provided to Dr. Lutzire. When asked whether it would be a breach of the standard of care for physicians who had links to those resources to choose not to read them, Dr. Moriarty stated, "I think it would be. All I can say is I think it would be strange not to investigate." She also agreed that if a physician had the data and a patient's family requested that ivermectin and MAP Plus be administered, assuming that the physician knew the patient wanted it, the standard of care would be to investigate further, and it would be a breach of the standard of care for a physician to choose not to investigate unless they had some good reason to not at least examine the data. Even Dr. Lutzire himself acknowledged that under the College of Physicians and Surgeons of Ontario's policies and guidelines, there's a prescribed duty to see out new knowledge and evidence, to share this knowledge with others, and to apply it in practice. This was not a question of urgency. A total of 11 days elapsed between Dr. Strange forwarding the literature and Ms. Stark's death. Dr. Moriarty stated that she would be confident in deciding whether to administer the treatment after reviewing the literature for 3 to 5 hours. Dr. Lutzire had the time. Having admitted to only having read one of the 64 studies concerning ivermectin trials, he had no good reason not to examine the literature to make an educated, evidence-based decision. Instead, he let his personal views about the treatment get in the way of his obligation to the patient. As the expert testimony established, his conduct did not meet the standard of care expected of a reasonably prudent practitioner. We also submit that Dr. Lutzire breached the standard of care by denying Ms. Stark treatment with MAP+. Canadian courts have consistently held that the exercise of reasonable care in the medical context requires sound and thorough investigation of the patient's condition. Writing on behalf of this court in Crawford and Penny, Justice Power noted that the proper exercise of judgment by a physician is one that is made after his or her weighing, assessing, and evaluating such information as may be available. The information upon which a judgment or decision is reached must be as complete as is reasonably available and possible in the circumstances. Justice Henderson expressed a similar sentiment in McGregor and Potts, stating that clinical judgment is not guesswork based on limited facts. Clinical judgment must be exercised only after the medical practitioner has informed himself of all the relevant facts, subject to any time constraints. I would like to briefly set out the facts of that case as they are relevant to the present matter. The defendant physician was found negligent in his decision to make a forceps intervention during labor. Prior to making the decision, he did not read the labor progress reports, flow sheets, or nurse's notes, and did not ask about the specific rate of descent of the baby. Justice Henderson held that having failed to inform himself, the defendant was not in a position to exercise his clinical judgment in favor of a forceps intervention. Further, he held that had the defendant been informed, it was not within the scope of his clinical judgment to recommend the use of forceps. Prior to denying Ms. Stark treatment, Dr. Lutzire did not inform himself of her improvement while receiving treatment with ivermectin and MAP+, nor did he conduct any due diligence to determine the safety and efficacy of the treatment. Having failed to inform himself, he was not in a position to exercise his clinical judgment when deciding to withhold administration of the treatment. Moreover, we submit that had Dr. Lutzire been fully informed, it was not within the scope of his clinical judgment to deny Ms. Stark treatment. The literature provided by Dr. Strange illustrates that COVID patients treated with MAP+ have a reported 6.1% hospital mortality rate compared to the average mortality rate of 23%. The ivermectin meta-analysis establishes that in 78 studies involving almost 86,000 patients, there is an average 64% improvement in the patient's condition. The defendant's expert, Dr. Moriarty, stated that she would prescribe ivermectin after reading 5 RCTs, showing beneficial results, safety, and effectiveness. In total, there are 33 RCTs involving 7,100 patients, establishing an average 56% improvement. Meanwhile, remdesivir, which is part of the hospital's COVID-19 protocol, was approved after only one study involving 1,063 patients with an average 31% improvement. I've already discussed the effectiveness of ivermectin, so let me briefly address safety. In a study combining results from trials of over 50,000 patients, serious events occurred in less than 1% and were largely associated with administration in Loa loa, a parasitic worm not found in Canada. Dr. Lutzire suggests that ivermectin carries a risk of liver failure.
Could I just briefly, it's my understanding that this drug's not approved by Health Canada. Is it your submission that the standard of care requires physicians to use treatments that are not approved by Health Canada?
I Our position is that if there is positive evidence out there, then yes. And I would
Commented
remind,
on how beautifully organized the Walker Moot is.
sorry, I would remind the court that Dr. Lutzire himself admitted that in the past he has prescribed off-label drugs that were not approved for that use. And when asked, he agreed that he would estimate that in 20 to 40% of cases, an off-label drug is prescribed in the treatment of a patient. Did that answer your question, Justice?
Yes, thank you, counsel. And it's your submission that the standard of care would require, because that's what we're talking about here, the standard of care requires this physician to prescribe this medication, even though it's not an authorized medication.
It is, yes. So I was about to touch on it, but I would refer the court to a statement Dr. Moriarty, the defendant's expert, made, where she said that it would be a breach of the standard of care to disregard alternative treatment in the face of positive and favorable evidence. So it is our submission that based on the evidence in the literature that Dr. Strange provided to Dr. Lutzire, it was the standard of care to administer that treatment.
Counsel, sorry, I have a question as well. Can you tell me, sorry, what was the name of that decision by Justice Henderson you were relying on?
McGregor and Potts.
McGregor. In McGregor, it seems like there was fundamentally a breach there because the defendant did not follow hospital protocol. In this case, the defendant appears to have followed protocol, and you seem to be saying that he nonetheless breached the standard of care. And I'm just wondering how you square that with Justice Henderson's decision.
Yeah, so our position is really focusing on the fact that the standard of care is reasonable, is based on reasonableness. And we're not necessarily saying that there has to be a perfect outcome or that a doctor has to prescribe every treatment that is out there and has ever been referenced. But in this case, Dr. Lutzire had the material, and all of the experts agreed that if you have that material available to you, that it's a standard of care the standard of care would be to review that material. And then, as I stated, the defendant's expert said that if that material shows positive results and efficacy, to administer that treatment.
Counsel, very, very quickly. So is it then your position that the breach is failure to read the materials?
We would say that it's a little bit of both. So first, there was a breach in failing to read the materials as established by the experts. But then in addition to that, we would say that had the defendant in this case read the materials and reviewed them as all the experts say he should, that based on the evidence presented in those materials, it would have only been the only reasonable exercise of his clinical judgment would have been to continue administration of the treatment.
Thank you, counsel.
Are there any further questions? Perfect. I'll continue. So, find my position here. Dr. Lutzire suggests that ivermectin carries a risk for liver failure. However, there are only two cases of reported liver injury associated with ivermectin, both of which resolve without the need for treatment. As I stated, given the evidence in the literature Dr. Strange provided, the only reasonable exercise of Dr. Lutzire's clinical judgment was to continue to administer the treatment. That concludes my submissions. Subject to any questions, I will pass it over to my co-counsel, Ms. Dowling, who will address the remaining two questions and issue. Thank you for your time, Justices.
Thank you, counsel. Just want to check with the moderator. Is there time for further questions? I don't want to
Yeah, there's about 1 minute and 30 seconds left. So, but if you guys want to ask questions that go over the 15 minutes, it's okay. It's more so they can't speak
Gotcha.
beyond that. But yeah, if you have a question, you can go ahead.
All right, counsel, I have another question. So the second breach, so the first breach I understand as being not following or not choosing to do his due diligence, reading the materials, etc. Is the second breach then that it's your position that not only does the standard require having read those materials, but the standard would require following those materials and pursuing the recommendations of those materials?
It is, yes, based on the evidence that is included in those materials. And again, I think the biggest thing that we're drawing on is just that statement by the defendant's expert that if you have evidence showing safety, efficacy of a treatment, that it would be a breach not to administer that treatment.
Okay, and so then put succinctly, am I correct in that it's counsel's position that the standard requires then to administer ivermectin or whatever the study suggests? Is that counsel's position?
It is, yeah.
Okay. Thank you, counsel.
Thank you.
I think, was that everything? Yeah, okay, so
It is, yeah.
yeah, Ms. Dowling, you can go ahead now.
Thank you so much. Good afternoon, justices. As my colleague mentioned, I will be addressing why Dr. Litzire's conduct did contribute to Ms. Stark's death and why West Valley Memorial should be held vicariously liable for this conduct. To begin, in order to assess causation, we use the but-for test. Would the plaintiff have suffered the same injuries but for the negligent acts of the defendant? In this case, we submit to the court that Ms. Stark would not have died but for Dr. Litzire's actions. When determining causation in the medical context, the law does not require scientific precision. Causation should instead be determined on the balance of probabilities. The Supreme Court of Canada held that the law can bridge a small factual gap in order to infer causation. And so I would bring the court's attention to paragraph 50 of our factum, where this was adopted in Gassi and Singh. Here, the court held that a judge is open to infer that should a treatment have been administered at an earlier point, this would have prevented the harm suffered by the plaintiff. In the present case, we submit that had MAF Plus been administered continuously, it similarly would have prevented Ms. Stark's death. This is a reasonable inference. When Ms. Stark was administered MAF Plus, her condition improved substantially. When Dr. Litzire withheld MAF Plus, her condition deteriorated rapidly. It seems as though MAF Plus was helping Ms. Stark greatly. In addition, the peer-reviewed literature available also supports this conclusion. When treated with ivermectin, one of the ingredients in MAF Plus, early improvement rates are 16.3% higher, clinical deterioration rates are 9.1% lower, and mortality rates are 16.9% lower. We also have expert evidence provided by Dr. Titchener and Dr. Strange, who stated that administering MAF Plus was the standard of care. They both suggested that if Dr. Litzire had met this standard, Ms. Stark's outcome would have been different. Based on the facts, the scientific literature, and the expert evidence, it is reasonable to bridge this factual gap and infer Ms. Stark would not have died if Dr. Litzire had continued to administer MAF Plus.
Counsel, I have a question about that. You mentioned that it's reasonable to infer that MAF Plus would have benefited and was the reason. Could it not have been because ivermectin is just one component of MAF Plus, that the other components were actually what was assisting in the treatment?
Thank you for your question. Absolutely. It is definitely possible that it was one of the other ingredients. But regardless, we still submit that the MAF Plus protocol itself, based on the evidence that we have, was helping Ms. Stark, and that by taking her off of MAF Plus, we can infer that that action caused her death, or at least contributed to her death. And so it's also reasonable to bridge the factual gap that had Dr. Litzire read the study sent to him by Dr. Strange, he would have been convinced of the efficacy and the safety of MAF Plus. The defendant's witness, Dr. Moriarty, stated that she only needed to read 5 randomly controlled studies regarding ivermectin for her to be convinced of its effectiveness. Considering how data-driven Dr. Litzauer made himself out to be, it is reasonable to assume that he would have been similarly convinced.
Council, I'm sorry to ask another question. I promise this will be my last one. The standard, as your previous counsel suggested, was that he would have been entitled to make a decision after reading the materials. So couldn't it have been entirely possible that he did read the materials, did not have that breach, and decided still not to use that? Would that not still have been reasonable then?
It's possible. However, based on all 3 of our expert witnesses, Dr. Moriarty and Dr. Strange and Dr. Titchener agreed that that was the standard of care to administer MAP+, and Dr. Moriarty agreed that if she had read 5 studies, she would have been convinced of the effectiveness. So we're just saying that we can bridge that small factual gap, and we're inferring that if he had read those studies, he would have agreed with the 3 of our witnesses based on the evidence that we've been provided.
Thank you, counsel.
So, but for the defendant's actions, it is reasonable to assume Ms. Stark would have been continuously administered MAP+, and her condition would have continued to improve accordingly. In addition, we submit to the court that Dr. Litzauer's actions were at minimum a part of the cause of Ms. Stark's death. The Supreme Court, as explained in Affey and Leonati, is of the view that the defendant's negligence did not need to be the only cause of the harm to be held liable for an injury. It was held that as long as the defendant is part of the cause of an injury, they are liable, even though their act alone was not enough to create the injury. And so in his discovery, Dr. Litzauer stated that if the standard of care was followed from the very beginning of Ms. Stark's hospital stay, she wouldn't have died. He believes that her condition deteriorated because Dr. Papadopoulos and the nurses on staff had breached the standard of care, and therefore they worsened Ms. Stark's health and contributed to her death. However, we submit that Dr. Litzauer's refusal to read the relevant literature and his withdrawal of the patient's preferred treatment were at minimum a part of the cause of Ms. Stark's death, and so he should remain liable regardless. Now, I would like to turn the court's attention to our final issue. Is the hospital vicariously liable for Dr. Litzauer's actions? We submit that West Valley Memorial should be held vicariously liable for his negligence because he was an employee and he was working in the scope of his employment at the time of the negligent actions. This is evident from his employment contract, his ongoing relationship with the hospital, and his hesitancy to deviate from the hospital's treatment protocol. The Supreme Court in Yepperman and Scarborough General Hospital held that a hospital is vicariously liable for a doctor's negligent acts only if they are a permanent employee of the institution. Accordingly, prior jurisprudence has not held hospitals liable for the actions of non-employees. Therefore, it is important to distinguish between an attending specialist staff retained by the patient to provide a service and an employee of the hospital. In the present case, Dr. Litzauer was an employee of West Valley Memorial. This is according to both his employment contract and where in his discovery, where he admitted that he performs medical services on behalf of the hospital. Therefore, Dr. Litzauer would not be considered an attending specialist staff retained by the patient to perform a service. In fact, Dr. Litzauer made it very clear in his discovery that Ms. Stark did not choose him as her physician, but instead he was assigned to care for her by the hospital. Therefore, as an employee of West Valley Memorial, Dr. Litzauer's negligence is also their responsibility, and they should be held vicariously liable for his actions. It is also important to determine if Dr. Litzauer was acting in the scope of his employment at the time of the negligent act. We submit to the court that he was, and consequently the hospital should be held liable. The Supreme Court has ruled that when assessing liability, it is important to determine the character of the defendant's employment at the time of the negligent act. It was held that it is a safer practice to determine if at the time the defendant was acting within the ordinary scope of their employment, or if they were outside the direction and control of the hospital. In the present case, Dr. Litzauer was acting in the scope of his employment at West Valley Memorial. He himself designed the hospital standard protocol set out in their COVID-19 treatment plan. And in his discovery, he admitted that he did not deviate whatsoever from the standardized protocol. He stated that he does this kind of work on a daily basis. And he gave absolutely no indication that his treatment of Ms. Stark was any different from the remainder of the COVID patients he's treated at West Valley Memorial before. So his negligent actions did not really deviate from what West Valley Memorial expected of him. And so he was clearly acting within the ordinary scope of his employment. Furthermore, we submit to the court that this hospital should be held liable for policy reasons as well. It is in all of our best interests for doctors to be good at their jobs. And although that clearly requires a degree of autonomy, it also means that they need to be given accurate instructions for what to do when they're seeing patients. Obviously, things will pop up, such as COVID-19, that nobody learns about in medical school. And when these situations arise, we need to be able to trust our hospitals to curate the best treatment plans possible. West Valley Memorial appointed Dr. Litzire to create their COVID treatment plan. They entrusted him with deciding exactly what happened to every single patient that had COVID that walked through those doors. They are responsible for a treatment plan that was developed by a doctor who could not be bothered to read a study that was directly sent to him by another physician, something that even the defendant's witness admitted was a breach in the standard. We should not allow that to go unpunished. Yes, Dr. Litzire should be held liable for his negligence, but West Valley Memorial should also be held responsible, as they placed a doctor in charge of creating a treatment plan who doesn't believe in taking a look at peer-reviewed studies that a fellow physician begged him to read.
Counsel, sorry to interrupt. Can I just ask a question? How do you respond to your friend's argument that the hospital really had no control over the defendant's clinical decision-making in and of itself? So therefore, the hospital cannot be held vicariously liable, even as a matter of policy.
Thank you for your question. I absolutely understand that argument, but our position is that by placing Dr. Litzire in charge of creating that treatment plan, that puts the hospital to a different standard than just a regular physician doing their job. Obviously, people like physicians need their own kind of autonomy, but in this case, Dr. Litzire continuously, in all of his depositions, stated that he followed the standard of care at that hospital. And so every single other physician or healthcare practitioner at that hospital can easily say, well, I followed the standard of care that this hospital told me. And so our position is that it's very important for hospitals to be very careful when they're curating these treatment plans and when they're deciding who they want to be designing these treatment plans.
Thank you.
So let's say a physician had refused to abide by the hospital protocol and he had decided to administer the experimental treatment that was requested. Let's say that resulted in negligence. Is it your position that the hospital in that case would be vicariously liable?
Thank you for your question. We believe that a hospital is still responsible for hiring that physician and for placing their patients under that physician's care. Although obviously the policy reasons would likely be very different, we believe the hospital should still be vicariously liable for the actions as long as that physician was an employee acting within the scope of their employment. If their breach in that hospital treatment protocol does not put them within the scope of their employment, we believe the hospital should not be held vicariously liable.
Thank you.
So not holding the hospital liable sets a dangerous precedent. Hospitals need to be diligent when entrusting physicians to curate treatment plans. We should encourage them to appoint physicians who are open to all scientific perspectives and take the time to read peer-reviewed studies that disagree with their opinion. They need to be open to changing their minds. By holding West Valley Memorial liable for Dr. Litzire's negligence, we are encouraging other hospitals to take more care when curating treatment plans, which will make us all safer in the future. To conclude, we submit that the defendant was negligent in his actions towards Ms. Stark. He owed a duty of care and breached the standard of care of a reasonable and prudent physician. It is unreasonable for a prudent medical practitioner to blindly follow protocol and to cast aside other methods of treatment as propaganda when that protocol has proven ineffective. It is also unreasonable that he denied Ms. Stark treatment with Math Plus as he did not thoroughly investigate her condition. By failing to inform himself, he was not in a position to exercise his clinical judgment when deciding to withhold administration. We submit that these breaches in the standard greatly contributed to Ms. Stark's death. Based on Ms. Stark's rapid improvement on Math Plus and her quick deterioration when the treatment was withheld, combined with the scientific literature and expert evidence, it is reasonable to bridge that small factual gap. We therefore conclude that but for Dr. Litzire's negligence, Ms. Stark would not have died. Finally, we submit to the court that West Valley Memorial should be held vicariously liable for the death of Ms. Stark. As an employee acting within the scope of his employment, Dr. Litzire was their responsibility, and they should share liability for the incident. It is also important to set a precedent that will encourage hospitals to keep us safer in the future. For these reasons, the plaintiff respectfully requests that the court award non-pecuniary damages for the death of Ms. Stark due to the negligence of Dr. Litzire. Subject to any further questions, this concludes our submissions. Thank you.
Thank you, counsel. Counsel, I have a question. Your friends acting for the defendants point out that the material contribution test here does not apply. You've referred to contributing and materially contributing. So I take it then you are suggesting that the material contribution test does apply here. Is that correct?
Yes, we do submit that.
Can you describe to the court why you believe it applies in this case?
We believe that the precedent that the Supreme Court of Canada set out does follow what the facts of this case. Dr. Litzire was negligent in the two different ways that my co-counsel has explained and elaborated. And that negligence, we submit that it did in fact cause the issues that happened to Ms. Stark, and it caused her death. And that what happened earlier in her hospital stay was not nearly enough in order to cause Ms. Stark's condition to deteriorate so horribly that Dr. Litzire was not in a position to save her. She was under his care for, I believe, over 11 days. And at this point, he absolutely had the power to ensure that she did not die. And so he did materially contribute.
Okay, so is it counsel's position that the only tortfeasor here was the defendant, but there weren't multiple tortfeasors who were all negligent? Is that counsel's position?
Yes, I believe so, along with the vicarious liability of the hospital.
Thank you, counsel.
If there aren't any more questions, thank you. And now the court will invite counsel for the defendant to begin.
Good afternoon. Good afternoon, Justice Strada, Justice Falco, Justice Priodka, Justice Lacani, and Justice Balaton. And also good afternoon to our friends, and thank you so much for your submissions. My name is Andrada Marinescu, and I represent the defendants. My co-counsel and I are here today to bring to light the true nature of Dr. Litzire's care for Ms. Stark, informed and evidence-based. To do so, we'll start off with a brief opening statement, and then we'll go into our main submissions, which comprise of four main parts in the following order. Firstly, I will address the requisite standard of care as correctly applied to this case. And secondly, I will explain how and why Dr. Litzire adhered to the standard of care. Followingly, my co-counsel will take the lead to explain the issue of causation and the issue of our friends' reliance on faulty scientific research. And lastly, we will also discuss why the hospital would not be found vicariously liable, even if Dr. Litzire were to be found negligent. It is implied thus that we submit that Dr. Litzire would not be found negligent for his care for Ms. Stark and should not be found, and therefore that the hospital should not be found vicariously liable. To begin with Dr. Litzire's requisite standard of care, we note that the prerequisite duty of care that is part of the finding of negligence is not an issue here today. We also agree with our friends that the requisite standard of care of Dr. Litzire in this case is that of an ordinary specialist in the same field and assessed in light of other ordinary specialists possessing a reasonable level of knowledge, competence, and skill. We say this on the authority of the Supreme Court in Terneuzen v. Korn. As such, because Dr. Litzire is a specialist in pulmonary and critical care medicine, we therefore submit that his standard of care was that of ordinary specialists in this field. We also note that this standard of care is notably distinct from a standard of perfection. In the context of treating COVID-19 patients, such as Ms. Stark, this standard of care manifested into a requirement and obligation to treat COVID-19 patients with the approved treatments employed by other average and ordinary specialists in pulmonary and critical care medicine. This inherently includes the requirement to use evidence-based medicine in the best interest of patients. We also respectfully submit that this is the correct standard of care because it is grounded on well-established jurisprudence by Canada's highest court and Ontario's highest court. Madams and Mr. Justices, I will now explain to you how and why the standard of care we just established was adhered to by Dr. Lutzier in caring for Ms. Stark. Our overarching argument as to this adherence is that Dr. Lutzier acted in conformity with the highly respectable medical community. In Turin-Newson by the Supreme Court at paragraph 51, Justice Sopinka held that a doctor will not be held liable for negligence if he acted in conformity with the recognized practice of his profession. We submit that this is an elaboration of the standard of care we established and not a way to avoid negligence. The plaintiffs bring forward two alleged claims of breach of standard of care. The first, as you noted, Your Honors, is the judgment called by Dr. Lutzier to, instead of embarking on an investigation of the documents in Dr. Strange's email, Dr. Lutzier instead chose to attend to his patients in the critical care unit at the height of this pandemic. The second claim was that accordingly, he chose to ensure that Ms. Stark was treated with the hospital standard COVID-19 protocol instead of Math Plus and ivermectin at Dr. Strange's request. We respectfully submit that these judgment calls adhere to the standard of care because Dr. Lutzier was well informed of the relevant, peer-reviewed, credible, and scientific literature necessary to best treat Ms. Stark. This is for two important reasons. The first of these reasons is that Dr. Lutzier held the position of leading the team of experts that was responsible for designing the COVID-19 protocol of the hospital. This team included a wide variety of medical experts in the relevant medical fields of pharmacology, scientific research, and pulmonary and critical care medicine, among others. We submit that Dr. Lutzier's responsibility of this team and participation in helping this team allowed him to be well informed because this team was responsible for reviewing all the most up-to-date, credible, and peer-reviewed research and also discrediting the treatments that they found were no longer useful to the hospital. They did this frequently and regularly. This can be proven by paragraph 94 through 132 of Dr. Lutzier's deposition. The second important reason why we know that Dr. Lutzier was well informed was that Dr. Strange contacted him before emailing him the documents. In this contact, we know for a fact that she informed Dr. Lutzier that the contents of the email would be regarding to Math Plus and ivermectin as a treatment for Ms. Stark, so specifically for COVID-19. We submit that therefore Dr. Lutzier was informed in making his judgment call because he was aware of the contents. And we submit that ivermectin, as a widely debated drug in the media and scientific community, would have inevitably come up in Dr. Lutzier's investigation along with his team and in his own personal research as his position in the hospital.
Counsel,
yes.
Sorry to interrupt, counsel, but I have a question. Your friend's position has been that he ignored reading these articles, which you agree are subject to much debate. Wouldn't it be a failure of the standard, which requires him to exercise reasonable judgment, if he only subscribed and was committed to what he believed, such that he didn't want to see anything else, including but not limited to Miss Stark's improvement?
Thank you so much for your question, Justice Lakhani. I respectfully submit that despite our friend's submissions of this situation, it was not that just Dr. Lutzier ignored the research. He asked Dr. Strange to email it to him, and then when he was informed of the contents of the email, he was able to rely on his well-informed status as someone who was responsible for the team of experts and participating in their research to use his knowledge on ivermectin as it was and all the knowledge of the proven and credible science that was being used in the hospital's COVID-19 protocol to be able to make the judgment call to continue ensuring the hospital's treatment. And therefore, it did not breach his standard of care that he did not investigate this research at Dr. Strange's will, because he was well informed regularly by reading the most up-to-date research along with his team.
Counsel, just as a follow-up, but couldn't it be seen that he was failing to see Ms. Stark's position in light of all the medical records and the medical documentation in support of it? However, Ms. Stark was reacting and improving on those treatments. Didn't he ignore that?
Thank you so much for your follow-up question. As to the fact that Ms. Stark seemed to be improving at certain points following an administration of ivermectin at the hands of the hospital staff, we submit that to assume that this was caused by ivermectin and Math Plus would be a conflation of correlation and causation. And we would encourage the court to rely on the credible science instead of to a co-occurring phenomenon.
Sorry, if I can ask a question that's somewhat related to that. As a matter of law, what is your position vis-a-vis the standard of care in terms of objectively, the defendant had to adopt this hospital's protocol, but subjectively, as Justice Lakhani just pointed out, there was some evidence that this treatment was in fact working in this particular case. So to what degree does that subjectivity vis-a-vis this particular plaintiff apply in determining the standard of care?
I believe there's multiple facets to your question, and I thank you again for it. I would submit again that the evidence that is claimed in this case as to the Math Plus and ivermectin working is not credible because it is inflation of causation and correlation. Furthermore, to back this up, we know for a fact that the documents that were sent by Dr. Strange to Dr. Luzier were not peer-reviewed. And therefore, we also know that many of the studies that were claiming that Math Plus and ivermectin were helpful treatments for COVID-19, many of them have been discredited and recalled by the peer journals that have published them. As such, as a matter of law, to answer your question, we respectfully submit that our position, and as a matter of law to this, is that the standard of care required Dr. Luzier to continually ensure that patients were being treated with the hospital's standard protocol, as this is based on the credible and peer-reviewed research, instead of one instance that would be a very small sample compared to the credible and peer-reviewed research that he was relying on.
Thank you, counsel.
Thank you for your question again.
I have a follow-up question to that. Did the doctor or does the doctor not have a duty to reassess when his course of action is not having the desired effect?
Yes, we submit that doctors should be continually evaluating the status of their patients. However, we submit that COVID-19 is a new virus that is not curable at this moment, and especially at the moment in time. At the moment, when Ms. Stark was being treated by Dr. Luzier, we'd submit that the hospital's COVID-19 protocol was the most credible and evidence-based standard treatment to be available. And even though Ms. Stark was unfortunately not surviving COVID-19 along with this treatment, we submit that she is a small minority that is very unfortunate to not be able to survive COVID-19. Thank you so much for your question. I would like to quickly wrap up the remaining of my submissions before my time expires. So I would like to summarize that the two main reasons why Dr. Luzier was already well informed was that he was well informed based on his responsibility and participation with a team of experts that was relying on credible and peer-reviewed data. And as well, he was aware of the contents of the email when he made his judgment call to attend to patients in the critical care unit instead of diving into evidence that he would probably knew was already discredited and inevitably would have come up in his regular research. So by way of this, I would like to relatedly submit that the second claim of breach of standard of care as to the fact that Dr. Luzier administered the hospital's COVID-19 protocol instead of Math Plus and ivermectin, we respectfully rebut this claim as well, because of the fact that Dr. Lutzier was acting in conformity with the respectable medical community. And we know this for a fact because he was ensuring the hospital's COVID-19 protocol by nature, which was backed up by, thank you so much for the extension, that was backed up by evidence-based research. I would also like to make a quick note to respectfully rebut our friend's reliance on the expert witnesses as to the standard of care. The two expert witnesses in this case, as designated by the court, are Dr. Titchener and Dr. Moriarty. While Dr. Strange also submitted depositions that we received, she is not technically an expert witness in this case. I begin respectfully with Dr. Titchener, as he is unable to refer to any credible peer-reviewed research and submitting that Dr. Lutzier's standard of care and administration of the hospital's standard protocol was medically unsound. Therefore, his statements on his breach of standard of care are unfounded. Secondly, he misconstrues the reality of the situation that Dr. Lutzier was in. And contrary to his submissions, Dr. Lutzier was not sitting there watching Ms. Stark die, and he was not uninformed in administering the hospital's COVID-19 protocol. As such, we respectfully discredit Dr. Titchener's statements as to standard of care. As for Dr. Moriarty, even though he is the defendant's expert witness, we do recognize that in a hypothetical situation, he said a doctor should read peer-reviewed research if he was sent them. But in context of Dr. Lutzier and Ms. Stark, he says the opposite. Therefore, we submit that our friend's reliance on the hypothetical situation that Dr. Moriarty was asked misconstrues his statements. We also submit that the hypothetical situation was not analogous to the case at hand because the data and studies sent to Dr. Lutzier were unfortunately not peer-reviewed. This can be fact-checked by the fact that they were not published by peer-reviewed journals. So in sum, I thank you so much for your time today, justices, and we respectfully submit that Dr. Lutzier did adhere to a standard of care, and that standard was that of an ordinary specialist in the same field possessing a reasonable level of knowledge, competence, and skill. Subject to any questions, I would like to allow my co-counsel to take the lead on the remaining issues.
Good afternoon, Mr. and Madam Justices. My name is Alexandria Ruigrok, and I'm co-counsel for the defendants, Dr. Justin Lutzier and West Valley Memorial Hospital. First, I will address the issue of causation, and then I will address our alternative argument that West Valley Memorial should not be held vicariously liable. Should this court find Dr. Lutzier to have breached the standard of care, we submit that his actions were not the actual cause of Ms. Stark's death. Ms. Stark had already entered the pulmonary phase of COVID-19 at the time that Dr. Lutzier assumed care of her, and her chances of surviving were therefore extremely low. While our friends have submitted that treatment with ivermectin or Math Plus would have saved Ms. Stark, we submit that these drugs have never been proven as effective for treating COVID-19, and as such, they could not have improved Ms. Stark's outcome. I wish to begin by briefly addressing our friend's submission that any potential contribution to Ms. Stark's condition, however minuscule, should result in Dr. Lutzier being found liable for her death. My friends quote the Supreme Court in Athey versus Leonati and ask this court to apply a material contribution test for causation in lieu of the but-for approach. However, we respectfully submit that the Supreme Court in Clements versus Clements has completely limited the material contribution test to negligence cases involving multiple tortfeasors. As such, we submit that it would be inappropriate to establish negligence using this test here today. The Supreme Court has consistently established that while but-for causation does not require scientific certainty, it does require the plaintiff to establish on a balance of probabilities that the patient's death would not have occurred but for the defendant's negligence. We submit that the appropriate standard laid out in Clements and affirmed in Edinger versus Johnson requires that Ms. Stark's death would not have occurred but for a proven breach of the standard of care by Dr. Lutzier. Per the Supreme Court's holding in Laferriere versus Lawson, we submit that this court should consider any potential faults by Dr. Lutzier alongside other identifiable causal factors leading to Ms. Stark's death. COVID-19 is the uncontested cause of Ms. Stark's death here today. We therefore submit that this court should carefully weigh any evidence presented by our friends against the well-studied progression of COVID-19 illness, which was evident from the moment Ms. Stark presented herself to the emergency room. Although Ms. Stark was a young, healthy woman prior to contracting COVID-19, she was unfortunately part of a small minority of COVID patients who cannot fight the virus. When she presented to the ER on October 5th, her infection had already progressed to the pulmonary phase. By the time Dr. Lutzeyer assumed care of Ms. Stark, she had developed advanced fibrotic lung disease. At this point, Ms. Stark was unfortunately in a position where she had already sustained severe irreversible damage to her lungs, and she would never be able to breathe the same again. Many effective drugs have been brought to market in the past several months to properly treat COVID-19, but unfortunately for Ms. Stark, these drugs were not on the market at the time of her illness. Although Dr. Lutzeyer treated Ms. Stark with the best evidence-based medicine available, statistics show that her chances of survival were very low. In our respectful submission, the issue of causation in this case hinges on understanding the true nature of the evidence in support of ivermectin and MAF+. These drugs have never been approved or recommended for the treatment of COVID-19 by any reputable health authority, and the research supporting them is both biased and scientifically flawed. Our friends, relying on the testimony of Dr. Strange, ask this court to bridge a factual gap and infer that Ms. Stark's death was caused by Dr. Lutzeyer's decision to not administer ivermectin. To that point, we respectfully wish to note that Dr. Strange was not called as an expert for this case, and the evidence that she uses to support her opinion is not peer-reviewed and has been heavily criticized by scientific bodies across the world. As such, Dr. Strange's opinion should not sway this court's decision on issues requiring expert evidence. In making their case for causation, our friends also rely on the opinion of Dr. Titchener, their expert witness. We respectfully wish to draw your attention to the fact that Dr. Titchener at no point in examination or cross-examination spoke about whether or not Ms. Stark's death had been caused by failure to supply her with ivermectin or MAF+. As such, we respectfully ask that this court set aside our friend's suggestion that causation had been established by expert evidence. Our friends rely on this court's decision in Gyasi versus Singh as support for their claim that administering ivermectin would have saved Ms. Stark's life. However, this analogy requires that ivermectin actually be a proven effective treatment for COVID-19. The World Health Organization, Centers for Disease Control and Prevention, National Institutes for Health, and Health Canada, among others, all agree that ivermectin has no proven benefit for COVID-19 patients. Peer-reviewed literature published to date concludes that ivermectin and MAF+ have no benefit for COVID-19 patients, and in fact may actually result in detrimental outcomes for those patients. In their factum, our friends attempt to conflate correlation with causation. This phrase comes up a lot in scientific discourse, but it really just means that someone has made an observation of two co-occurring phenomena, and then they have attempted to attribute one phenomenon to the other phenomenon. In this case, our friends suggest that Ms. Stark's on and off progression of COVID symptoms are somehow linked to the occasional administration of ivermectin or MAF+. However, given that there is no reputable scientific literature to support this inference, it cannot pass the bar of correlation to become a causal inference.
Counsel, your friends suggested that there is evidence in which there have been instances and reports in which patients have been saved by ivermectin treatment. Is it your position that there's absolutely no evidence of any instances whatsoever in which ivermectin has saved patients?
Thank you for your question, Justice. So our position is that in their factum, and I believe in their oral submissions, our friends have relied on literature authored by Pierre Corey. It's the same literature that Dr. Strange sent Dr. Lutzeyer by email, and I believe that is the only scientific evidence that they cite. This literature, contrary to repeated claims by our friends, is not actually peer-reviewed. And in fact, Dr. Titchener noted in his examination at paragraph 35 that Corey's one peer-reviewed study published has actually been retracted by the publisher. And the study was retracted because it falsified mortality data in an effort to make MAF+ seem effective. So our position is that while there is quote unquote published evidence, it is not reputable. It does not meet the standard required to inform evidence-based medical decisions. And therefore this court should not rely on that sort of internet published discredited evidence to draw a causal inference.
But counsel, as you've conceded that there is a debate amongst the community, and so if there had been studies in which individuals had been saved by ivermectin. Could this not have been one of those situations in which ivermectin was having an improvement and could have saved her?
So thank you for your question. I would hesitate to guess about the efficacy of a drug just when most of the scientific evidence, in fact, the overwhelming burden of scientific evidence says that it isn't effective. But I would argue that our position is that you cannot possibly draw a causal inference from observing one patient when the overwhelming body of properly conducted peer-reviewed literature says that there is no benefit, and in fact, there can be some detriment. And so based on a brief single administration of ivermectin and a brief single administration of Math Plus, it would not be consistent with the scientific method to assume that there was any positive effect of those treatments. Does that answer your question?
Thank you, Council.
Thank you.
Council, I have a question. I think what you're saying that the treatment was experimental, it's still debated, but in this case, so was the hospital protocol was also ineffective, not working in this patient's case. Would you agree that a physician would be justified in administering potentially experimental treatments to a patient for whom all the standard treatments have been ineffective?
Thank you for your question. Our position is that in consistency with the standard of care that has been set out in numerous medical handbooks that we've referenced in our factum, including some from the College of Physicians and Surgeons, I believe. Just because a patient requests a treatment does not mean that the doctor is required to administer it. And at the moment, the recommendation from Health Canada and most other scientific bodies is that if patients are to receive these types of experimental treatment, they only do so in conjunction with an approved clinical trial, a phase 3 clinical trial. And so our submission is that it would not have been appropriate to administer an experimental treatment to this patient. And it would have actually been going against recommendations by Health Canada and other high-ranking advisory bodies for Dr. Lutzier to do so. Thank you.
So I have a question on causation. Sorry. It's more an issue of law. You're saying that the material contribution test on which your friend relies does not apply in cases of multiple tortfeasors. Can you explain the ratio behind the Clement decision and why we should not be relying on Athy and Leonatny, which says that if there are a series of causes, the defendant can still be held liable?
Certainly. So I thank you for your question. Firstly, I would note that the Athy decision, I believe, was a much older one, whereas the Clement's decision and also the Edinger decision, I believe, were both made following the English mesothelioma cases. And even in light of that new jurisprudence coming out of the British court, the Supreme Court continued to enforce the standard of requiring multiple tortfeasors. And I believe that that requirement was based on, if you diminish the standard that the plaintiff needs to prove for causation, it makes it a more even playing ground when there are so many potential tortfeasors who are all likely liable that they could either all point fingers at each other, as in the case of the English mesothelioma cases, I believe, or that you just couldn't possibly, there couldn't be any redress for the harm to the plaintiff because of the multiple tortfeasors. In this case, on the facts at hand, there's no evidence that there was more than one tortfeasor. And so that exception to the rule would not be applicable to this case because there's no requirement for the burden to be diminished.
Thank you, counsel.
Thank you. So moving on, and to the point of the literature that is relied on by our friends, authored by Pierre Corey. In the event that this court does choose to rely on our friends' studies as evidence of causation, we submit that these studies actually conclude that ivermectin could not have improved Ms. Stark's outcome. The researchers in the meta-analysis submitted by our friends conclude that late treatment with ivermectin is not recommended. The same meta-analysis indicates only a 23% improvement in outcome for patients who receive ivermectin late, which they define as once symptoms have worsened, as Ms. Stark's had in this case when she arrived at the hospital. And this finding comes with a p-value of 0.056, which if you're not familiar with statistical significance, the universally accepted significant level is a p-value of anything under 0.05, which means that even this small potential improvement for late administration, which is not recommended, has a significance level that is below the cutoff point for being of any use. So even by the evidence submitted by our friends, ivermectin could actually not have improved Ms. Stark's outcome at the point that Dr. Lutzier assumed care. While we wish to respond to our friend's factum submission that Ms. Stark's death was caused by the delay in transfer to Dr. Strange's care, we respectfully acknowledge that the delay in transfer to another hospital was not an issue before this court today as a breach, and we refer you to page 8 of the MOVE package. With respect to the issue of vicarious liability, we submit that West Valley Memorial Hospital is not vicariously liable for the actions of Dr. Lutzier, regardless of any possible negligence on his part. The hospital does not exercise control over Dr. Lutzier's clinical decision-making because Dr. Lutzier holds a high-ranking supervisory role at the hospital. We submit that the hospital is further protected from vicarious liability because Dr. Lutzier acted in the capacity of an attending physician rather than as a hospital employee while providing care to Ms. Stark. We submit that this court should examine the specific circumstances at hand to determine whether or not Dr. Lutzier acted as a hospital employee during the course of the alleged negligence, in keeping with the Ontario Court of Appeals approach in Upremian versus Scarborough General Hospital. Typically, hospitals are not held vicariously liable for the negligence of attending physicians on their medical staff because attendings are engaged in granted privileges, just as independent contractors are. Dr. Lutzier's role and duties at the hospital more closely resemble those of an independent contractor than a servant or employee. As hospital chief, Dr. Lutzier exercises supervisory and decision-making power far beyond what is normally accorded to a staff physician. On the evidence available, Dr. Lutzier is subjected neither to oversight nor managerial control by the hospital. And this distinction is important because the Supreme Court has established that an employer's control of their employee is an essential defining quality of the employer-employee relationship. We draw this court's attention to the Supreme Court's opinion in the Sagaz case, where Justice Major for the majority noted that, quote, the essential criterion of employer-employee relations is the right to give orders and instructions to the employee regarding the manner in which to carry out his work. In that case, the Supreme Court held that Sagaz was not vicariously liable for its contractor because while they controlled what their contractor did, they did not control how the contractor carried out his duties. We submit that the same test should be applied here to find that the hospital neither controlled how Dr. Lutzier developed COVID treatment protocols, nor how he treated patients on a day-to-day basis. We further submit that although Dr. Lutzier was party to an employment contract with the hospital, he was not acting in the scope of his employment at the time of caring for Ms. Stark. When Dr. Lutzier assumed care, he took over from a third-year medical resident after discovering that the resident had been administering ivermectin to a patient in contravention of the hospital's policies. At this point, Dr. Lutzier intervened pursuant to his duty under Section 34 of the Public Hospitals Act and began acting as an attending physician in lieu of the resident he took over for. We respectfully submit that the doctrine of control in this case also invokes important policy considerations. In Basley versus Curry, the Supreme Court identified that the purpose of finding an employer vicariously liable is to deter future negligence, and redress damages. If the employer does not control the activities of the worker, the policy justifications underlying vicarious liability will not be satisfied by holding the employer liable. We therefore submit that holding the hospital liable would not be justified in this case, given the hospital does not exercise control or oversight of Dr. Lutzier in his duties. We respectfully disagree with our friend's counter-argument that the relationship between Dr. Lutzier and the hospital should be defined by his use of hospital equipment and assignment of staff. While these factors are relevant to the employment relationship, we submit that the Supreme Court has analyzed such relationships on a case-by-case basis, applying different weight to such factors depending on the particular circumstances of the case. In these circumstances, we submit that such details are immaterial to defining the master-servant or employer-employee relationship, because attending physicians also use hospital equipment and staff and are normally found to be contractors rather than employees. In closing, we submit that this court should not find Dr. Lutzier or West Valley Hospital liable for Ms. Stark's death. We submit that the standard of care at hand was that of an ordinary specialist in the same field as Dr. Lutzier, possessing a reasonable level of knowledge, competence, and skill. By keeping abreast of evidence-based medicine and continually reviewing the hospital's COVID-19 treatment plan, we submit that Dr. Lutzier met the standard of care at all times during his care of Ms. Stark. We submit further that Dr. Lutzier has consistently acted in conformity with a respectable body of opinion during Ms. Stark's treatment. The COVID-19 treatment which he administered was backed by credible, peer-reviewed science from reputable sources. Dr. Lutzier at all times provided Ms. Stark with the best treatment available. On the issue of causation, we submit that our friends have not overcome their burden to prove that Ms. Stark's death would not have occurred but for Dr. Lutzier's actions. We submit that Ms. Stark's condition would have continued to worsen, regardless of any intervention available at the time, and that neither ivermectin nor Math Plus have been proven as effective treatments for COVID-19, and therefore Dr. Lutzier did not cause Ms. Stark's death. And finally, regarding vicarious liability, we submit that Dr. Lutzier's relationship with the hospital at the time he cared for Ms. Stark was one of a contractor. We further submit that he was acting outside of his employment contract at the time he treated Ms. Stark, and as such should be treated as any attending physician who responded to the call to treat COVID patients in an emergency. Subject to any further questions, that concludes our submission, and we thank you for your time.
Thank you, counsel. I just have one final question is with respect to the reasonable diligence and responsiveness to care. Your client, Dr. Lutzier, completely went against everyone else and decided to stop treatment that was helping and prohibited others from even intervening or considering. Would it not be a breach, or maybe it's a better fit question for your friend, and I'll let either of you answer. Would it not have been a breach for him to not consider any other views, including what was happening in her specific circumstances?
So our submission, thank you for your question. And I don't mean to speak in lieu of Ms. Marinescu, but our submission is that because the hospital treatment protocol was developed in conjunction with a team of the highest ranking, best educated experts in all of the relevant fields, Dr. Lutzier at all times was taking into account the positions of other experts. He was not taking into account the position, for example, of a third-year medical resident who is not yet licensed by the college when he stopped, I believe it was Dr. Papadopoulos, from administering ivermectin. But his choices at all times were informed by a respectable body of opinion that was made up of evidence-based medicine, research, and a number of other leading experts in the relevant fields.
Thank you, counsel.
Thank you. If there aren't any more questions, the court now invites counsel for the plaintiff to begin their optional 3-minute rebuttal if they wish to use it.
Thank you so much. We do wish to use the rebuttal. So we would like to first remind the court that Dr. Lutzier admitted to having read one of the 64 ivermectin studies. We would respectfully disagree that he was in a position to ignore the data. We also submit that Dr. Moriarty read the literature and agreed it would be a breach for a doctor not to examine those documents if they had access to them. Opposing counsel mentioned that Dr. Lutzier's position is in conformity with the recognized practice of its profession. But we submit that this position is not in conformity, as our witnesses state that much of the medical community disagrees with Dr. Lutzier's position. They're not completely unanimous about the state of ivermectin or Math Plus. We would also like to rebut the statement that Dr. Lutzier was well informed simply because he was the leader of the COVID treatment plant team. Just because the team was responsible for reading the relevant literature does not mean they actually did look into that literature. As we know, Dr. Lutzier carefully picks and chooses what studies he decides to read and ignores studies that disagree with his opinion. Opposing counsel also submit that he inevitably would have come across those studies regarding the efficacy of ivermectin, but he acknowledged that he was not well informed about ivermectin. Opposing counsel kept encouraging the court to refer to the credible science. However, all the physicians that we deposed agreed that RCTs are credible science. Opposing counsel also submitted that Dr. Titchener is not a reliable witness, as he could not come up with a study to back up his claim. We remind the court that neither Dr. Moriarty nor Dr. Lutzier named a study that backs up their position. Opposing counsel submitted that Dr. Lutzier did not cause the damage because Mr. Stark had already gotten to the pulmonary stage of COVID-19. We submit that she would not have gotten to that stage had she been administered Math Plus continuously. Also, we would disagree that there is no evidence that of ivermectin's effectiveness. The meta-analysis establishes that there are 78 studies involving almost 86,000 patients showing 64% improvement. And of those studies, 58 of them are peer-reviewed. Meanwhile, remdesivir, which Dr. Litzire administered, was approved after one study involving 1,063 patients. We also disagree on our opposing counsel's position that we exclusively relied on Dr. Corey's paper to educate ourselves on ivermectin and MAP+. We also greatly relied on the meta-analysis Dr. Strange provided. Opposing counsel also submit that Dr. Litzire would have inevitably come across studies of the efficacy of ivermectin, but he acknowledged that he did not know very much about ivermectin, and he was not very well informed. We would also like to remind the court that opposing counsel referred to Yepperman and Scarborough General Hospital to argue that West Valley Memorial should not be vicariously liable. The basis of that case was that the hospital should not be liable for non-employees, as the physician in question was not an employee of the hospital. There was no employment contract. In this case, we submit that Dr. Litzire's, he was an employee. We have an employment contract. He admits that he was performing services on behalf of the hospital. And so our facts are completely different from those in Yepperman v. Scarborough General Hospital. We also disagree that he just became an attending physician because he provided the medical treatment that his employment contract provided for. He was an employee. We have an employment contract. And so the precedent in Yepperman would not apply in this case. Thank you so much.
Thank you. And this concludes the matter of Stark v. Lutzire.